morning to all of you. First of all, I wish to thank Professor Sant'Angelo and the University of Catania for having invited me for this concise summary on intellectual property rights. This is a great honor for me, and I hope that my short presentation will be of help for any of you who is interested in deepening the knowledge of intellectual property rights. A few words about me. After graduation in mechanical engineering and some years spent at University of Bologna, I left my PhD course and I started to be trained in Turin in a big IP law firm. Then I started the IP department of a big company in the fitness industry, and then I started my own business in Roncuzzi&Associati, where I work now as professional. Roncuzzi&Associati is a small firm with a good reputation in the IP law scenario in Italy. What is intellectual property? It's the general name given to intangible assets, which derive from creative efforts and the way to communicate them in order to be distinguished by others. That is to say, property of something that has not a physical existence. For instance, while a product exists physically, the rights of the inventor in that product do not. Intellectual property is a rapid changing area of the law which follows the transformation of the society and of the human mentality. That's why I'm so fond of IP and the law that regulate this matter. The majority of the issues that arise within this area is about intangible property rights, which are afforded legal protection. Here we have a slide which helps me to briefly present what IPRs are, particularly who, why, and where IPRs are so important. IPRs deal with humans' creativity, inventions, distinctive signs, designs, trade signs, and copyrights. Of course, this list is not definitive at all because the human's creativity every day builds new and different situations that might be worthy to be protected. Today, we are going to concentrate on registered IPRs, such as patents, utility models, industrial design, trademarks, that are topic plenty of rules that deserve to be known. Creativity is probably what more distinguishes humans from other creatures that populate the world, either when they approach life alone or when they do it in organized groups. That's why individuals and organizations are allowed to file applications to get their assets registered. They only had to decide whether investing money to be granted a registered IPR is really of use for them. But anyone who wishes to approach intellectual property has to bear in mind that jumping into the intellectual property is a non-return step. One can think to be an entrepreneur or not, but applying to a registered title exposes the applicant to the judgment of others that has to check very carefully if their creativity deserves the grant of a monopoly. Therefore, a real entrepreneurial attitude does require challenging approach to problems, being curious, humble, and resilient at the same time. The filing of an application for a patent, a trademark, or an industrial design is the expression of a voluntary disclosure of the intention to get the grant for that specific intangible asset. The grant is accompanied by the birth of an exclusive right, a sort of monopoly, which is a very smart opportunity for the applicant, but it does represent a severe limitation to the freedom to operate of their present and future competitors. That's why procedural steps are mainly examination steps, aiming to assess if the claim of the monopoly is admissible. The very basic requirements of patents, trademarks, industrial designs are established by the Paris Convention that has been ratified in 176 states in the world and is in force since 1882. That means that almost every state in the world is part of the Paris Convention. The Paris Convention is managed by the WIPO, meaning the World Intellectual Property Organization, which is one of the United Nations organization agency which is based in Geneva. In 1994, The World Trade Organization, WTO, issued the Agreement on Trade-Related Aspects of Intellectual Property Rights, briefly TRIPS, which sets down minimum standards for many forms of intellectual property regulation as applied to nationals of other WTO members. TRIPS was negotiated at the end of the Uruguay round of the General Agreement on Tariffs and Trade, GATT, in 1994. The TRIPS agreement introduced intellectual property law into the international trading system for the first time. It is the most comprehensive international agreement on intellectual property to date. In 2001, the Doha Declaration clarified the scope of TRIPS. Specifically, TRIPS required WTO members to provide copyright rights, geographical indication, industrial designs, integrated circuit layout designs, patents, new plant varieties, trademarks, trade dress, and secret information. TRIPS also specify matters that are not regulated by the Paris Convention, such as enforcement procedures, remedies, and dispute resolution procedures. At any rate, not all the contracting states of the WTO apply the Paris Convention and the TRIPS literally. Very often, each state or regional authority disciplines special aspects of IPR through the law system and jurisprudence. Taking into account the European Patent Office, the European patent applications are regulated by the European Patent Convention. It disciplines European patents, starting from the filing of an application, the assessment of patentability of inventions therewith described, the patent grant, the opposition to grant, the appeal procedures, and many other related aspects. However, the European Patent Convention does not regulate the relationship between the owner and its counterparts. Therefore, it is not what is usually called a patent system. For instance, the patent section of the Industrial Property Code, which is in force in Italy, it is a patent system. However, all the regional and national laws set down that each grant can be revoked in case it's possible to prove a misinterpretation of the position of the object of the application in respect of the prior art or the fulfillment of the requirements established by the pertinent law. Local and regional courts manage limitation and nullity actions of grant and IPRs after the definitive conclusion of their administrative procedure. For instance, when IPRs are fully enforceable right. In the large majority of countries, only lawyers are admitted to court. In Italy, it's the same. This fact usually makes the procedure more structured and the costs usually much higher. Most IP systems make available a remarkable administrative procedure called opposition that can be launched before the administrative IP authority to limit or cancel an IPR already granted or narrow to be granted, close to be granted. In Italy, opposition is allowed in front of the UIBM only for trademarks. European Patent Office and the Office for Harmonization in the Internal Market, OHIM, admit opposition respectively against the grant of European patents and of community trademarks. Opposition can be managed without lawyers. You immediately understand that this has many pros and cons. The main pro is, of course, the reduction of the costs. Nevertheless, also here in this field, spending less not always brings more advantages. Now, let's say something on the main IPR tools, starting from patents. Patents are registered designs related to solution of technical problems. Patents grant the owner the exclusive right to exploit the referred inventions in a determined territory. However, patents are grantable only if the solution of each technical problem is described in its application, described very well, very precisely. The condition of clarity is set down by the law to admit to grant all inventions that are easily understandable by simply reading the text which accompany their patent applications. However, full understanding of an invention does not mean that the invention is freely exploitable by anybody. This happens only after the patent validity is expired, which might occur even before the maximum duration fixed by the law. For instance, it might be the consequence very easily of the lack of payment of the periodical government fees. Please bear in mind that the matter of invention must be novel and obvious worldwide, over the known prior art for a person skilled in the art, I mean at the date of the patent application. Novelty and non-obviousness are requested to be sure that the inventor carved a new track in the world of the techniques. However, novelty does not matter with invention being smart or ingenious, but it is necessary to say that it is definitely in danger if someone at any time could prove that the teachings of the invention had been divulged before the filing date of the patent application, wherever filed, in whatever state in the world. Please note that IP laws define inventive step in the negative form, state that it arises when the invention is not obvious, and it's very difficult to understand what it means. However, trying to give a brief explanation, this means that the invention has to perform a surprising effect for a person skilled in the art, particularly if this person already knew the problem before the application date. Now let's get into trademarks' main topics. Each registered trademark is made of 3 items: one sign, at least one out of 45 classes, subdivided in many categories according to the international NIS classification under the WIPO. A territory, meaning at least a national or regional district. Additionally, to be registered, signs have to be novel and distinguishable. That's why they are supposed to identify the origin of product services in determined fields without any risk of confusion and easy the choice of a product or of a service provider. Novelty must be checked where the trademark is to be registered, not worldwide as in case of patents. The checking is made by making a comparison with local valid prior trademarks, taking into account verbal, conceptual and phonetical issues. On the other hand, distinguishability occurs when the name and logos are fancy without any link to the product or service to be distinguished by the trademark. Consequently, great attention has to be paid when choosing a sign for a trademark. If the sign recalls products or services that have to be marked, the risk of confusion with similar trademarks is very, very high. Simple variation of the wording or immaterial changes to the graphical representation make trademarks of others novel and indisputable, and of course we do not want that. And now a few words on last topic of today: industrial designs. They relate to the aspect of a product or of one of its own parts, on condition that this aspect is new and present individual character. The law specifies that parts may be lines, contours, colors, shape, texture, materials of the product itself, or decoration of the goods. Novelty returns again and has to be assessed by a worldwide comparison with rights already known at the date of the first public presentation of the design concept. After this date, in some locations, a grace period of 12 months is allowed to applicants. This happens in Europe, in the US, but it does not happen in other states such as China and Taiwan, for instance. Turning to the individual character, it occurs when the overall impression of a design on an informed user differs from the overall impression that other design made available to the public before the date of filing of application make on the informed user. And now some words on where apply for IPRs. Of course, multinationals have a different approach to the filing of IPRs than a small company. However, unless your company is in the pharmaceutical industry or it deals with energy, for instance, you might not need to file worldwide IPRs. Always, wherever the nature and strategy of the company make it profitable to invest money to gain a privileged position and the benefits it provides for. In some regions, it is possible to benefit of unitary conventions to be granted of IPRs that are enforceable the same way in all the states of the region. Very easy to understand that this allows to reduce costs and simplify administrative procedures. In Europe, only the community trademark and the community design, administered by the Office for Harmonization in the International Market, work like this. Unitary patent is supposed to come to light within the end of 2017. Finally, my last point of this lecture is why building an IPR portfolio. Please remind what we said before. Each IPR is a monopoly, grants a privileged position to its owner, conditions the competitor strategy, facilitates the management of one's know-how and networking, eases the restoration of infringed rights by simplifying the related legal activity. However, even though all these issues are of the utmost importance, an additional point hugely expands the importance of IPRs in each kind of business. It makes your firm more suitable for tax planning and for merger and acquisition operations. Therefore, it makes your firm more attractive to investors and, definitely, more profitable for you. Thanks for your attention and see you in Catania next year.